For Module 4, we're going to talk about the different types of notices. This is a little longer of a module, but it's very important. Here we have the 7-day pay or quit notice. This is what it looks like. It's very straightforward and to the point. We say name tenants only because there are situations where we'll have a house that has multiple renters in it and we only want to evict maybe someone out of one of the rooms instead of the entire house. If we are thinking that, there are other people who are living in the house and we may not know their names, we're just going to put the person whose name is on the lease, and then we're just going to click and all tenants and all occupants. That's what that means. So we use this notice when tenants have not paid the rent, or maybe they've only paid a partial amount of the rent. We could serve this notice the day after rent was not received. If there is a grace period, you have to wait until the grace period has ended to serve this lease. It is the landlord's right to refuse a partial payment. So if the total owed comes out to $1,200, for example, and the tenant pays $1,000, it's kind of up to the landlord to determine, okay, am I going to take the $1,000 or am I going to reject the $1,000 and say, listen, I need the full amount of rent that's due and owing, which is the full $1,200. If the landlord refuses the rent, they have to give the rent back right away. If it was electronically deposited, they can call their bank and ask for it to be given back, or they can simply write a check out to the tenant saying, here's your money back, I need the full amount or nothing at all. If the tenant does pay the full amount that ends up on this bottom line here, then no eviction can take place. You can't evict them after the rent has been taken. If you do want to accept maybe the 1,000 out of the 1,200, that's okay. That just means that this total amount owed is going to be 200 instead of 1,200. We have the 5-day pay or quit, very similar to that of the 7-day. The main difference is, let's go back to the 7-day here real quick, that there's a cap on late fees. It can't be more than 5% of whatever the rent is. Okay, so this law just recently changed in July of 2019. They put a cap on late fees, and it's not 5% per day or X amount per day. It's 5% period. So whatever the rent is, you can only charge 5% no matter how late it is. For the 5-day pay or quit notices, as I said, this can only be served for commercial properties. As you can see here, there is nowhere on this notice where it says that there's a cap on late fees. That is the main difference here between the 5-day and the 7-day. Next notice we have is a 5-day notice to quit for tenant at will. So tenant at will is a tenant who allows someone to stay in their home for an undisclosed amount of time, rent-free. So as I said before, a good example of this is a friend comes to the tenant or maybe even your home and says, listen, I've fallen into hard times. I just need a place to crash for a little while. And you say, of course, come on in. You can stay for as long as you need just to get back on your feet. And then basically they overstay their visit and they never leave. This would be an appropriate response, would be a 5-day tenant at will. 3-day notice to quit for nuisance and waste. This one can be very, very effective. You can see there's many reasons here that you can check mark of why you are evicting your tenant. And we kind of talked about this earlier. The thing is with this notice, this is very, very important for this notice, is that this notice needs proof. Landlords can't serve this notice if they think their tenant is subletting or committing waste or any of these. If you suspect something, that's not the same as actually proving it. You must have proof of this. That includes pictures, video, red cards, which are given by police when they are called to the property, neighbor testimony, either that neighbor comes into court with you, or you have a letter written from the tenant or from the neighbors, I apologize, or anything that proves what you're claiming in this notice. The 5-day notice to perform a lease condition, like I said earlier, this one can be fixed by the tenant. And if they bring proof to court saying, yes, the yard was really unkept, I got a HOA violation, but I hired a gardener, I fixed it, all is well, and here's pictures of the yard, it looks a lot better now, then that would be really good to have. If it's maybe an old photo, right? Because some tenants will try and pull a quick one on you when you go to court, and the picture that they'll show the judge will actually be the picture when they moved in of the yard looking good, and it doesn't look like that now. It doesn't hurt to just swing by the dwelling and just kind of take pictures of your own, because those are timestamps, so you can show the judge, actually, judge, that was from when they moved in. Here's an actual photo of what it looks like. Okay, and another reason that we would do a lease condition, the most common one, is, say for example, we're selling the property or we're trying to sell the property. We give the tenants a 24-hour notice saying that, we're coming into the property to show a potential buyer what the inside looks like, so please grant us access, and they don't. They can't do that, especially if you gave a proper 24-hour notice. And for my property managers out there, 24-hour notice is very informal. Just say, dear tenant, we are going to be entering the property between 10 a.m. and noon on this day, and please allow us access. And that's it. Keep it very simple. Keep it simple, keep it short, to the point. The 30-day no-cause notice, landlords can give this to their tenants 30 days before their lease expires if they do not wish to sign a new lease with them. This can also be given on a month-to-month tenancy. So maybe their lease expired back in 2008. That doesn't mean that there's not a lease. There's still a lease, it's just turned into a month-to-month tenancy. So this can be given anytime during a month-to-month tenancy. Landlords cannot give this notice in the middle of their tenants' leases. So if the tenant signed a year-long lease and they're maybe 8 months into their lease and the tenant or the landlord has just had enough of this tenant, which understandably can happen, they can't say, you know what, you're out, you gotta go. Here's a 30-day no-cause notice. You can't do that. You have to wait 30 days before their lease expires, or when they're already on a month-to-month. The 7-day no-cause notice can only be given if someone's been in the property for less than 30 days. So if they're paying you weekly or bi-weekly, this is the kind of notice that we would give to that kind of tenant. You could always give a 30-day instead of the 7-day if you want to give them a little more time to get their belongings out. We would give a 30-day no-cause notice if this person has a ton of stuff, because it's going to be impossible for them to get all their belongings out. Or if you just want to, just give them extra time out of the goodness of your heart, that's always an option as well. The 5-day unlawful detainer, this notice is very, very straightforward as well. As you can see down here, you're going to write the township that the property is located and the address of the justice court where they can go and file a response. Oops. When we give this notice, this is the notice that we give to after every single notice except for the pay or quit notices. So all notices require a 5-day unlawful detainer. If the lease is expired and the landlord does not collect rent after the expiration of the lease, as I mentioned before, a 5-day unlawful detainer can be served by itself. But in order for you to do this, you have to serve your informal 30-day notice saying, listen, we're not going to be renewing the lease. And that is the end of Module 4.